Greetings, everybody. It is JC from the JC and Shaman Show. If you wish to come on Wednesday and ask questions, we are on TalkShoe at Common Law Word Nerds. You can also find us on Facebook at Common Law Shamanism. And you good people get a twofer today because apparently some attorneys have made me very irritated and I had to make another video about them pointing out some facts of law. Because that's what I like to do. I like to talk about the law. So, we're going to get back to the 1902 Code of Civil Procedure. And this is basically just showing how courts used to operate, how when they were changing from the common law to the administrative process that they call a civil procedure or a civil law or a civil code, how they were really just codifying the common law. So when we're looking at it here, it says the following rules shall be observed in the court of magistrates. And this is basically the lower courts, but you can always start an action in the lower courts and take it up to an actual court of record. They don't talk about the procedures on how to do that, but it's absolutely, they make some mention of it a little bit before this. The pleadings in the courts are the complaint by the plaintiff, the answer by the defendant. So that's really how easy a common law court is that you have a claim, you have an action by the plaintiff, and then you have an answer by the defendant. 2. The pleadings may be oral or in writing. If oral, the substance of them shall be entered by the magistrate in his docket. If in writing, they shall be filed by him, and reference to them shall be made in the docket. So basically, this is just going over the common law rule that it all has to be verified. That's why it's oral. If it's in writing, it has to be sworn to by oath or affirmation. But this is how easy it used to be. Any man could just walk down to the courthouse and swear out a complaint. They didn't even have to know how to read or write. They would just go before a magistrate, just move before a magistrate, and it was the substance that was important. It was not the form. It was not the form of writing. It was not the terms and legal terms of art that they use today. The complaint shall state in a plain and direct manner the facts constituting the cause of action. You always have to explain to the court exactly what the facts are, why you're there. Remember, the wrongdoer always summons the court. So, what did they do wrong? How did they do it? Where did they do it? When did they do it? I don't know if anybody in here has ever taken classes in journalism, but in the journalism you have the 5 W's: who, what, when, where, and why. Just keep that in mind, but you also want to make that as simple as possible. The answer may contain a denial of the complaint or any part thereof, and also a notice. There's a general denial, or they could just deny certain parts, and this is where attorneys go point by point back and forth. Also a notice in a plain and direct manner of any facts constituting a defense or a counterclaim. Whenever you got served with the complaint, you could make a notice basically stating, here are the facts as I see them, and this is my defense. Or you could have some type of notice that, hey, if you keep proceeding with this action, because you know the facts and I know the facts, I'm going to have to sue you for what you did in the given situation. Pleadings are not required to be in any particular form. because remember, it's the substance that is important. It's not the form, it is the substance. But must be such as to enable a person of common understanding to know what is intended, which means you have to make it pretty simple so, a 6-year-old can understand what the right and the wrong is in the action. Either party may demur to a pleading of his adversary, or to any part thereof, when it is not sufficiently explicit to enable him to understand it, or it contains no cause of action or defense, although it be taken as true. So basically, what a demur is when you say, yeah, I agree to everything you're saying, so what? Like, I agree to your complaint, wah, 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 but where's the harm, injury, or loss? This is a matter of law, so basically, I don't care. Let's take it to court, and that's what a demur is. And at this point in history, the courts were still accepting demurs. They have gotten rid of them because of the Civil Code of Procedure and because of the civil law. When you demur in civil law, it's like the code's already written out. Okay, so you're not actually going in and arguing points of facts because the code is what they produce, what they try to show people as law, and it's not. It's a civil procedure, it's an administrative procedure, it's not a court of law. And as I explained in the last video, you have the right to due process of law. It's not the right to due process of administrative procedure. Point 7. If the court deem the objection well-founded, it shall order the pleading to be amended, and if the party refuse to amend the defective pleading, shall be disregarded, which basically means that if you don't state a claim, the court can relieve. If there's no claim of actual wrongdoing, and they think that maybe there might be a claim of wrongdoing, the court would give you permission to amend the complaint or amend the answer. And if you didn't do that, then the pleading itself would be disregarded by the court. Okay, this is the last one I'm going to go into today. So number 8, in any contract where a defendant does not appear and answer, the plaintiff may file proof of service of the summons and complaint, or of summons on one or more of the defendants, and that no answer or demur has been served upon him. When the action is for the recovery of money only, judgment may be given for the plaintiff by default if the demand be liquidated and if unliquidated, and the plaintiff itemize his account and append thereto an affidavit that is true and correct and no part of the sum sued for has been paid by discount or otherwise, and a copy be served with the summons on the defendant, and the defendant shall neither answer or demur, the plaintiff shall have judgment for the sum sued for, as in the case of liquidated demands. In all other cases where the defendant fails to appear and answer, the plaintiff cannot recover without proving his case. And basically, what this rule is all about, it's where they're separating law and equity. On contract, if you have equity in something and the defendant doesn't answer, you have to prove your case. You would still have to actually take it to trial. The defendant doesn't actually have to show up for trial. But in law, where you're suing for money only, you can recover it with the default judgment. But I like the idea of having the sheriff drag somebody in to answer my action rather than getting a default judgment. A default judgment can be challenged at any time because everybody has the right to property and their money until they have an actual trial, and a default judgment is not a trial. Anyways, I hope this has been educational, and I hope that it's kind of getting clear that average people shouldn't have to pay thousands upon thousands of dollars to attorneys to get justice and right done in the courthouses today. It should be simple, it should be easy, and it used to be. They have changed it over the past 100 years, but if the people require the courthouse to act lawfully again, they will. It's just going to take the people to require it. Anyways, I am just conspiracy, and I just wish to conspire with other good people of this planet to leave a better world for future generations than the world that we all grew up in. Thank you.
It was my introduction to a culture that has abandoned justice. I teach law school and I speak to young law students all the time, students just entering law school, and I like to ask them, why are you coming to law school? And they raise their hand with idealistic answers like, I believe in justice, I want to help the community, to make the world a better place. And I then go on to share with them one of my favorite quotes from an unnamed law student. The first thing I lost in law school was the reason why I came. I tell them, you're about to start a first-year curriculum where you are going to learn the law is about rules and doctrine. It's reduced to black letters on a white page. You will soon forget there are people behind these cases. The law teaches you that we have to think but not feel. The legal profession devalues humanity. As lawyers, we are expected to perpetuate a cold, uncaring, process-driven system, and that starts in law school.
Some of our most cherished human rights have become forced into a dependence for their realization on a prior order of rights for global capital. And that this prior order of rights for global capital is deeply destructive of the human rights of human beings everywhere. So I was really a bit taken aback by this. You know, and if you ask the average person at the average British bus stop, which I sometimes do because I'm a bit of a liability, quite frankly, about corporate human rights, they'll say, well, they're not even human, are they? They're not even human beings. And there's a fundamentally intuitive insight there. So I was really intrigued, what is it about, law that makes corporate human rights seem so natural to the legal system and so odd to the rest of us? And so I dug down, and to cut a very long analysis short, what I discovered is that deep in the DNA of law, there is a particular vision, allegedly us. But this vision is a template of a human being. It's ultimately the rational man, but disembodied. And in fact, you could argue that the rationality of the legal person, in some fundamental sense, depends on its disembodiment. Now I hear you gasp as one. My goodness sake, this is hardly human at all. Correct. It is not. The legal person is like a persona or a mask. It doesn't fit us. And this strange disembodied something that is this hyper-rational reasoner of law, which is meant to stand for all of us, actually stands for none of us.